Well, good evening, everybody. Just been out with the hounds for a wolf pack meeting, it would seem. But time to crack on with the next bit of this video that we were looking at. I think Saturday, actually. I do apologise for not doing it Sunday, but Sunday was rather busy. And we got to that point in the conversation where the dude asked Professor Leo specifically about the read technique. Was the well, we'll hear it ourselves, but we got to that point where he asked, was the read technique used in full, and should that be appropriate for a juvenile, and particularly, sorry, I hit the wrong button there, particularly somebody such as Brendan. So let's share this now with you. Yeah, there we go. Make sure I click on share sound. That's very, very important. Okay, and let's just, as you can see, lots of people in the chat. Some very well-known names there: Scales of Injustice, Check and Convictions, Alice in Wonderland, Michelle Vernon, Fenn, Dark Side of the Moon. Now, I think we had a pretty good selection of people just around Bob. So yeah, plenty of people there. So anyway, let's just full screen of that. Let's just move me out of the way.
Say that you're not supposed to apply a full read technique to a kid like Brendan, or at least that was the impression I got, and I'd like to get your thoughts on that. I mean, was a full read technique being exerted on Brendan, and two, should it be exerted on a kid like Brendan?
Well, the read method, the so-called read method or the read technique, is an umbrella. So if you read their manual, they have dozens and dozens of techniques. I think they fall into a few broad categories, but some of them, it seems to me, are appropriate and some are inappropriate. It depends which ones we're talking about. And also, yeah, we know that juveniles are more vulnerable to psychological pressure and manipulation, more likely to make false confessions. And so we have to be especially careful about how we interview and or interrogate juveniles. You could have a system that allowed more aggressive interrogation, but had better at the front end, but had better controls at the back end, or didn't allow more aggressive interrogation, regardless of the controls.
Right.
I think Brendan was doubly handicapped by the fact that he was a juvenile, as well as the fact that he's intellectually low functioning. And so somebody like that, we have to be especially careful in how we allow police to interrogate. To me, one of the saddest facts about Brendan's interrogation is that it was recorded, and for decades, my work and other people's work have been pushing for electronic recording, thinking that this would be a real solution because people would be able to see both coercion, psychological coercion, the breaking of somebody's will, as I believe happened in Brendan's case, and also what we call contamination, which you're all familiar with, the leaking and disclosing or feeding of information. Perhaps the most poignant scene in episode 4 of Making a Murder season 1 is when they feed Brendan after he can't guess the head injury, how the head injury occurred. And so even though we have 5 hours of interrogation showing psychological coercion and contamination, he was still convicted. His conviction was upheld at the state level. It was upheld at the federal level. So this is an all-around tragedy. Yeah. And, I don't know how we strike the right balance between allowing juvenile interrogations but making sure we don't get juvenile false confessions. Such a big problem.
Well, on that note, we might want to speak to my good friend Zelma here, because the work that she does is brilliant. I've had her on before to talk about this, and essentially she is there to facilitate this kind of contact. If you want to go ahead and explain a little bit about what you do, Zelma.
Sure. So I would be doing a true interview with a child. And in Brendan's case, and I know we discussed this before, Brendan would have been a candidate for what I do. I'm a forensic interviewer. And so when Brendan was initially looked at as a possible witness, that's what he should have been interviewed as, a witness to crime. And he should have been seen by someone like myself who would do the exact opposite of an interrogation. In fact, our job is to, once the introductions are made, to do as little talking as possible. In fact, the most commonly used phrase in our interviews are, "Tell me more about that." So, yeah.
Right. And that helps to protect, I would say if more states were doing that and at least it would mitigate some of the damage getting done, I would say, if more states were doing that sort of thing.
Yeah. Well, let me tell you about something that I just was trained in last week. We have a new interview. It's not new, but it's kind of up and coming. It's called expanded or extended forensic interviews. And Brendan would actually qualify for that type of interview because of his disability. And what that would mean is we would have actually seen Brendan over a number of 2 to 4 interviews. But in each one of those interviews, there would not be a repeated question or a repeated situation that we want to know more information about. I think the problem that we see in Brendan's repeated interviews was they constantly went back over the same things repeatedly over and over and over again. And what children do when you ask them questions repeatedly is they start to change their answers. And so that is in effect what makes Brendan look inconsistent, which is why his statement should have been completely thrown out.
Right.
Since February, all homes in Scotland are required to have interlinked smoke and heat alarms. Wireless interlinked alarms give...
So, yeah, I think that's brilliant. And I just think things like that could be very helpful. Have you seen stuff like that, Dr. Leo?
Well, yeah, the forensic interviewing field is a really good field. There were some mistakes in the 1980s, and there was a lot of research and protocols and training and recording. And so the quality of interviewing that is done of children and juveniles as witnesses, as victims, as suspects is very good. That's exactly the right approach that Zelma is describing that I think should be taken. And it's the anti-Reed approach. It's not guilt presumptive, accusatory, confrontational, confession-driven interrogation. Right. It's true interviewing designed to get at the truth.
Right, sure, absolutely.
Could I ask Dr. Leo a question?
I was just about to cut to you, so you absolutely may.
Dr. Leo, I wanted to ask you what you thought about the proposition that a juvenile, someone under the age of 18, should not be able to waive their Miranda rights unless in the company of a lawyer or proper advocate.
Well, I want to start by saying that, I've written a couple books on Miranda. It's been something I've also studied for a long time. I might be considered a Miranda cynic. Most people in America waive their rights. Now, what you see in some cases, like the Central Park jogger case, for example, is the parents become kind of adjuncts to the interrogation. So they would put more pressure on their kids to tell the truth and be duped by police who say, the best outcome will be if your child cooperates. I think if you had a lawyer with the child, then there would be no waiving of Miranda. All the lawyers would invoke. And so you shut down the interrogation. And so you have to ask as a public policy matter, do we want to create a rule where if you're under 18, you can't be interrogated by police? And that's
alone without anyone representing you. So if you have a lawyer present and you could be interrogated, provided, of course, the lawyer's there. So
right. But the lawyer is going to say, I'm not going to allow my client to be interrogated.
Right.
And so what I'm saying,
99% of the time, right? Yeah.
So the thing is, the lawyer is going to shut down the interrogation.
Sure, but would that not be, if he's representing the best interests of his client, that would be the best outcome for that person who otherwise would be interrogated. Otherwise, the lawyer's not doing their job.
Correct. Yeah. So that's why I said it's kind of a bigger policy issue, because then you'd have to ask the question, well, from a societal perspective, do we want to shut down juvenile interrogations, even if it's always in the interest of a suspect, juvenile or not to speak to the police? So I think it raises a bigger policy issue.
Yeah, I guess it certainly would. My concern is that we're sort of potentially preferring the interests of the police over that of the suspect or the person being interviewed, and that person is entitled to the presumption of innocence. And if their lawyer is saying, don't answer that question, even though they may have been willing to answer other questions, isn't that the role of the lawyer? And if that was the case in Brendan's interviews, he wouldn't be where he is today, because no competent lawyer would have allowed him to answer those questions that were being put to him.
Right. The only thing is that the lawyer in America would say, don't answer any questions. It wouldn't be on a question by basis.
But would that, if you asked Brendan Dassey that question, that if you put that proposition to him, I should say, do you think he would have been better off if he hadn't answered any questions of Wiegert and Farkas?
No, absolutely. Yeah, he would have been better off. Absolutely. Yeah. But the question is, should we build social policy based on one case?
Right, exactly. I get what you're saying, Dr. Leo.
I mean, I like the idea of, I think in my state, in California, 15 or below, you have to consult with a public defender now before you can be interrogated, at least so you get some advice. But I'm not opposed to the idea of having some kind of consultation with counsel. It's just that it raises bigger questions, bigger policy questions.
Right.
Can I just throw something out? I know that the job that I do, it's really designed for victims, right? So Brendan would have only seen us because he would be a possible witness to a crime as a child. But I just want to throw out that there have been times that we've done interviews because we're concerned with the child, and it's usually involving sexual abuse. But sometimes juveniles will start to disclose their own role in a crime. Maybe they'll say, I did these acts. Now, as a forensic interviewer, I stop it there and I just say, that's not why you're here. I'm concerned about you and if this has ever happened to you. But at that point, once I'm done, then law enforcement steps in, because now they know they have something to investigate. I think that could be something that would be worked out with law enforcement. Let forensic interviewers have a first crack at these kids just to make sure that they're okay, see what they saw, because kids do tend to be really honest if you make them comfortable and let them know that they're not in trouble. Sometimes, even if they're guilty of something, it'll kind of flow naturally. We don't have to interrogate them to get them to say if they've done something wrong.
It seems like if Brendan Dassey had been interviewed by somebody like you, instead of interrogated by the police, he wouldn't have been convicted. He would have said he didn't know very much, and the outcome would have been much more just. And it seems like if you have somebody interviewing juveniles, you will get confessions. And so you could have a rule in the United States, since in our criminal justice system, juvenile justice is supposed to be different from adult justice. Juvenile justice is supposed to be about rehabilitation, that police don't get to interrogate juveniles accused of crimes. They have to be interviewed instead by forensic interviewers in a question and answer mode that's not accusatory, confession driven. I don't know how realistic that is, but that might be an alternative to Miranda and lawyers, right? So there's no coercive pressure. There's no attempt to get a confession. There's not even any police, but there's also an opportunity to try to get information from the juvenile.
Right.
They know something about the crime or may not.
I know what you mean. Getting people to agree, that could be tough. I get it. But I kind of like the idea of that process, because that process seems to be more focused on getting at the truth rather than somebody's preconceived notion of what happened. You know what I mean?
Yes.
So I do like that. All righty. Was that all your questions there, Mr. Hodnott?
For the moment.
For the moment. So Dr. Silkman, who is also from Australia, is there any question you would like to ask?
I've got plenty of questions, but first of all, thank you very much, Professor. Yep, I'll only ask one. Thank you very much, Professor Leo, for that. My question is, how would you, as a professional in the field, how would you assess the performance of Fassbender and Wiegert in their interrogation of Brendan Dassey, and how do you see their top 3 mistakes that they did when they interviewed Brendan Dassey on March the 1st?
Well, I think they're poor interrogators, so I would assess, at least based on that interrogation, that's the only one I've seen. So I would give them a failing grade and say they should go back to their training. I'm going on memory here. I haven't recently read the report, but or studied the case. You know, I mean, I've looked over it several times over the years, but I would say one problem we've already talked about is the feeding of details, the contamination. Obviously,
Yes.
they're educating him, putting words in his mouth. This is a no-no, even in police work. The police manuals say you don't contaminate, you don't give facts. You want the suspect, after they confess, to give you the facts that are not public, not likely guessed by chance, and you even hold back private.
You might be asking yourself, well,
inside, not
Yes.
likely guessed information, so that they can verify or show their ignorance, as Brendan did here, and that gives you an idea whether it's an accurate or inaccurate confession. So
Yes.
one big mistake, contamination. Of course, I write about that in my report.
Yes.
But as we talked about, it's really that moment. It's almost iconic in Making a Murderer from the interrogation. Illustrates it 1,000 times better than anything I could write. I thought Brendan, and I also write about this as you know in my report, but I thought Brendan Dassey's interrogation was psychologically coercive. There were implied threats and promises and inducements and benefits. That too, I think, was a problem. So I'd say that was a mistake. And then I would say the insensitivity to the fact that they were interrogating a juvenile who was low functioning, right? And police need to be trained about that. And it's, they pretend like he's an adult, like he's normal, and they run roughshod over his limitations. So those would be the 3 big issues. But I was very troubled, as all of you are, by that interrogation. Interrogations.
I was going to say, thank you, Doctor. I was going to say, I've read your report, your affidavit, and your analysis of the interview was absolutely spot on, and you dissected all the major points. My final point, if I could just say, just quickly, what I'm deeply concerned about is the fact that Judge Duffin saw right through all the garbage and highlighted basically the points that you highlighted in your report. Yet what is disturbing is that Brad Schimmel was still very, very persistent and basically went over what the judge said and kept on putting new filings all the time. So how come a judge can actually see the deficiencies in an interrogation like that, and yet the Attorney General was not happy with the judge's decision?
Well, I'm not sure I know the answer to that question. I would say that in the American legal system, there are multiple avenues for appeal.
Yes.
And so he was just appealing it perhaps up the chain.
Yes.
And as you see, there's a lot of different judicial takes on what happened.
And Brad Schimmel knew he had AEDPA on his side.
He had what on his side?
EDPA. Brad Schimmel knew he had EDPA on his side, so that was obviously another factor that would probably factor into that.
Yes.
Yeah.
May I have a supplementary question, Your Honor? Based on Dr. Silkman's questions to Dr. Leo. I wondered why the lower court judge, this is not meant to be a silly question, didn't analyze the confession, because there was an application to have it thrown out. So Judge Fox was the judge in Brendan's case. There was an application to have that confession thrown out that was denied. And I'd wondered, in your experience, whether you've seen confessions constructed in the way Brendan's was being thrown out by lower court judges as being improper.
You mean the judges at the trial, right?
Yes.
Right.
Oh, and in the preceding matters before the trial. There was an application made for the conviction.
So at a pre-trial hearing that precedes the trial.
Right.
I've seen confessions thrown out. Yes, I don't think it's the majority outcome at all. You know, maybe 10% or 5% of the cases I've worked on, I've seen them. I mean, I even think 10% is high. Maybe 5%, maybe 1 in 20. And then there's a selection bias, because if I'm working on a case, that means a defense attorney has seen a problem that would lead them to contact me. So it's not just a random sample of cases. So it does happen. It just doesn't happen that often.
Right.
And particularly in this case, because there was no corroborating evidence to the confession. So what's the role of judge to allow evidence to be admissible? I mean, it's a bit scary that type of thing can be admissible in a court of law, given all that we know about these sorts of confessions.
Right. The way the American judicial system is structured is that the judge is supposed to decide on voluntariness and Miranda, not on the reliability of the confession. The idea being that a jury can decide on the reliability. So when you say there's no corroborating evidence, a judge in America, a typical judge would say, but that's not my issue. My issue is, did it overbear his will? Was it an involuntary confession, or were Miranda rights violated? Now, it seems like we all agree. The judge should have said this was coercive. It elicited an involuntary statement. Whether or not it's unreliable, the trial judge at the pretrial hearing should have suppressed or excluded the confession by Brendan Dassey, and none of us would be here, and the world would be a better place, right?
Right.
But a different system might put more emphasis on reliability pre-trial. The American system does not do that. Now, I wrote a law review with Peter Neufeld of the Innocence Project, Steve Drizin, Brendan Dassey's lawyer, in 2013, looking to the law of American evidence and some provisions in it to argue that the system should not only be focused on the constitutional voluntariness of the confession, but also let judges exclude confessions if they are unreliable as an evidentiary issue. And then the article explained how we could use some non-constitutional American law to achieve that end. So I believe in the premise of your question. I'd like to see judges say, this is a garbage piece of evidence, and I'm not going to let it go before a jury because it's going to taint the jury. It's too prejudicial. There's no reason to believe it's probative or has any indicia of reliability. I wish that had happened in Brendan's case.
Right.
And I think the evidence to support that perspective is Brendan actually gave evidence in his own trial. He recanted under cross-examination and under the pressures of court and the obligation to tell the truth. He recanted everything, but that didn't count in the minds of the jury relative to the actual written confession.
Right. So jurors tend to be prone to convict. Right. So and they think that people are self-serving when they recant or deny. Yeah. So leaving it to the jury is not always a good solution. I think defenders of the system might say, well, you know, any system is going to be imperfect. Innocent people are going to be convicted. The best we can do is create a high bar, create rules like beyond a reasonable doubt. But my response would be the judge is supposed to be the gatekeeper of reliable evidence and unreliable evidence, and we don't want unreliable evidence to go in front of the jury.
Right.
Yeah.
And, you know, you touched on something there. I mean, when I had retired FBI agent Steve Moore on, you know, he was talking about how if he had taken the case that Wiegert and Fassbender had built against Brendan, and he was walking into federal court with that he would have gotten laughed out and might have possibly been sanctioned. Like, that's what he says would have probably happened if he carried that into federal court as an FBI guy. And it makes me wonder about the different standards. I mean, the state courts seem to kind of have a bit of a lower bar than the federal courts. Have you kind of experienced that or noticed that?
Well, I've worked on.
Well, let's leave it there. Let's have a. I love all the facial expressions. Let's stop it there, and we'll let Professor Richard Leo answer that next question from the dude. I just think it was a great interview. Richard Leo there, you know, a real expert in the field. So much so, I mean, you know, how much more credit do you need than the fact that Steve Drizin Steve Drizzen himself asked you to look at Brendan's case. There's the justification for saying that Professor Leo is a real expert in the the interrogation techniques of the American police and the American legal system. I just found everything that Professor Leo said was very interesting. It was interesting, I suppose, in particular, in that obviously Professor Leo knows that he's coming to talk to people who are very much in support of Brendan and are critical of the legal system, but at times he's having to point out, I get your concerns about it. I have similar concerns, but there is the other side of the argument, which says that when you've got so much crime going on, it's a tricky one, isn't it? Anyway, we have to, I suppose, accept the fact that that this is the way that the legal system works. Although I like the idea that himself and Steve Drizzen and Peter Neufeld got together to try and look at problems in the legal system, and certainly going back to what the panel was saying there. I remember Steve Drizzen tweeting about the fact that he'd been to a presentation with Laura in Birmingham, UK, and an police investigator came up to him and said, if I'd have done what we got on Fassbender did, I'd be out of a job, pure and simple. So it all boils down to, I think, the gist of what we were sort of getting at in that discussion there was the inadequacies of the judges. And I can only point out that, it's judges are voted on. They're voted in and out every 4-6 years, whatever it is. And it's something that's well known. You're not going to put out an advert to say that, well, I threw out this confession because I thought it was wrong. People want to go with the the ones that we're tough on crime. We're gonna make America safe again. You're gonna do well by voting for us. Anyway, I'm rambling on a bit. Just proving that I am a haver, as the dude would say. But anyway, part 3 coming up shortly. I'll say cheerio and maybe take the dogs on another walk. I don't know. Let's see. Okay, catch you all soon. Bye for now.